Shomayim, Shomayim, Good evening. How's everybody doing? Great to be learning with you on a Wednesday. Let's light up the darkness with a new wisdom candle. Who's in the house? Yehud in South Carolina, Stephen in New Hampshire, Paul in the Great Northwest, Sharon in New Jersey, Lucy in Minnesota, Bella in Florida, Shandora in the Bronx, Bill in mid-Missouri, driving back, making his way to mid-Missouri, and the other Paula in Chicago, Karen in Northern California, David in South Bend, Nancy in North Carolina. David, hello from Toronto. I don't think I've seen you here before. Welcome. Jonathan in LA. Grams, another new name, in Grams Alma in South Carolina. Guy in Ohio. Frank in San Pedro. Marjorie in Georgia. Aoife in Florida. Chaim in Florida. Welcome, everybody. Our daf, our page is page 88. Here in Tractate Bava Kamma, the 21st volume of the Talmud. We're continuing to discuss Mishna number 3 here in chapter 8. And we're going to make a bit of a digression. We're already on a digression. Generally we're talking about damages, right? This whole tractate has been about damages. Here in chapter 8, we started by discussing how do we know that an eye for an eye does not mean that the court steps in and takes out the eye of somebody, who injures another person, causing them to lose an eye. There would be too many problems. The Torah could not have meant that. And so the sages showed by various proofs that what it means is monetary damages. So now we've been looking at the 5 types of monetary damages, the actual compensation for the damage caused, as well as pain and suffering, loss of livelihood, medical costs, and humiliation. I always get confused, right? Damage, pain and suffering, loss of livelihood, medical costs, and humiliation, right? And then how it's measured depending on who is the person injured, who is the one doing the injuring. And we got to a discussion about, thank God slavery doesn't exist anymore. It hasn't for thousands of years. But when slavery did exist, there was a difference between if a Hebrew slave was damaged because the Hebrews, a Jew's servitude as a slave was temporary. He had to pay off a debt. He got caught stealing, something like that. And a Canaanite slave, which was a permanent servitude. And then what happens if you cause damage, if you injure a slave, which is going to cause a loss to the master, right, in the sense that the work won't be performed. And does the master actually collect, or do the damages actually accrue to the slave, him or herself? We looked at some comparisons to the law of a minor, right? Because if a minor finds something while living in the house of the father, that the found object, which cannot be returned for whatever reason to the owner's despaired. The owner can't be identified, so then it's finders keepers. But the child doesn't keep, the parent does, legally speaking. And so we're starting to get a little bit away from calculating damages for an injury, and that's going to continue today. So we picked this up about halfway down, page 88a. And like this. So Mar, the son of Ravina, said, the verse states, fathers shall not be put to death for children. Deuteronomy 24:16. Now, when we hear that, sounds like, well, that's common sense, right? That if a child commits a crime that's a capital offense, why should the father be put to death because of the capital offense of the child? Even if the father has some responsibility for being a bad father and not catching the signs, whatever. If the child, commits murder, why would the father be put to death? But that's actually not what this verse means at all. right? This is another case why we need the Talmud, why we need the Torah Shebal Peh, right? The oral Torah that accompanies the written Torah in order to understand what is actually being discussed here, as the sages say. Or in this case, Mar, the son of Ravina, said. The verse states, fathers shall not be put to death for children, meaning that people shall not be put to death based on the testimony of fathers who do not have common lineage with their children, right? So already this is very interesting. So first of all, what they're really saying is that fathers shall not be put to death for their children, and vice versa, is that a parent is not brought to testify as a witness against a child, and vice versa. So that's the simple level. And then beyond that, we're going to learn that certain laws that are, because we're talking about a parental relationship, well, does a parental relationship exist in the case of a slave? Does a parental relationship exist in the case of a convert, as we shall see? Right, so again, Mar, the son of Ravina, said that the verse states, fathers shall not be put to death for children, meaning that people shall not be put to death based on the testimony of fathers who do not have common lineage with their children. And this is referring to Canaanite slaves, whose children are not considered to be related to them. I mean, one more reason why slavery was awful is that when a Canaanite slave had a child, the child was considered the property of the master and not the offspring of the slave, right? Because parents and children in slavery could be separated. I mean, it's one of the terrible aspects of slavery. For if it enters your mind to interpret the verse according to its straightforward meaning, as we say, fathers shall not be put to death for children, even the straightforward meaning doesn't mean that a father would be put to death for the sin of the child. Rather, that fathers shall not be put to death for children. And that the straightforward meaning would be that by the testimony of their children, they would not be put to death, right? This is an obvious, to the sages, that's obviously what it means. But that's an insufficient interpretation, right? So again, for if it enters your mind to interpret the verse according to its straightforward meaning, as we say, fathers shall not be put to death for children, meaning by the testimony of their children, then let the merciful one write, fathers shall not be put to death for their children. What does the verse teach by stating only children? Without the word their, or it's not for, but their children. Fathers shall not be put to death by children, not their children, right? So why does the verse only state children without the word their, as in their children? Learn from this formulation that people shall not be put to death based on the testimony of fathers who do not have common lineage with their own children, meaning slaves. Right? So at the end of the day, what this becomes is an impediment to the death penalty, right? Because if the only witness was a Canaanite slave, we're not going to accept the testimony of a Canaanite slave in a capital murder case, right? That's the upshot of this. So the Gemara challenges this. If that is so, when the end of the verse states, nor shall children be put to death for fathers, Deuteronomy 24:16. Does this also mean that people shall not be put to death based on the testimony of children who do not have common lineage with their fathers? But if that were the case, it would also be the case that a convert would be disqualified from bearing witness, as one who converts no longer shares common lineage with his parents, right? So when somebody who is not a Jew converts to Judaism, his Hebrew name, let's say he takes on the Hebrew name Reuven, so he would be Reuven ben Avraham Visara, right? His parents are understood to be Abraham and Sarah, the father and mother of the Jewish people. And while he can maintain a beautiful, warm, loving relationship with his parents, right, with his birth parents, under Jewish law, they are not his parents for matters of Jewish law. When it comes to, inheritance law, property law, contract law, etc., it's like he is reborn when he converts to Judaism, and his parents are not considered his parents under Jewish law, right? It's not that he has to, put them off and disrupt his relationship with them, not at all, but legally speaking. So the Gemara challenges this. Right. So are we going to say, in other words, a convert loses the connection with his parents, but if he has children, obviously he has connection with his own children. Legally speaking, they are of course considered his children because they're born Jewish. The child of a Jew. He may have converted or she may have converted. That's irrelevant. Once somebody converts, while there are certain legal differences, it is actually prohibited to remind them or to speak about the fact that they converted because they're as Jewish as anyone else. Okay, so the question is, are we going to say that a factor of whether somebody can testify in a capital case according to this law from Deuteronomy 24:16, that is somebody who has, both connection, legal, lineal connection to their parents and their children. And if they don't have that, then they're disqualified from bearing witness in a capital case. That's the question we're asking. So the sages say in response, how can these cases be compared? With regard to a convert, although he has no common lineage with those above him, right, meaning his parents, he's understood to be the child of Abraham and Sarah, he does have common lineage with those below him, his children, his Jewish children. And this serves to exclude a slave who has no common lineage either with those above him or those below him. Right? When he becomes a slave, he doesn't have legal relationship under Jewish law, neither with his birth parents nor with the children that he has while a slave. So the sages prove that a convert is fit to bear witness. Seems like they just proved that, but now they add, as if it enters your mind that a convert is disqualified from bearing witness, then let the merciful one write, fathers shall not be put to death for their children. According to the interpretation that we say, fathers shall not be put to death based on the testimony of children. And let the merciful one also write, nor shall children be put to death for fathers, from which you learn two laws. One, that children shall not be put to death by the testimony of their fathers, right? A father will not be put to death by the testimony of his children. A child will not be put to death by the testimony of his father. And also, people shall not be put to death based on the testimony of children who do not have common lineage with their fathers, i.e. converts. You might have thought this. And the halacha with regard to a slave being disqualified from bearing witness is derived from a kal v'chomer inference from the law of a convert. And just as with regard to a convert, that it is the case concerning those above him that he has no common lineage, but with those below him he does have common lineage, and he is disqualified from bearing witness, then with regard to a slave who has no common lineage with those above him or those below him, all the more so is it not logical that he is disqualified from bearing witness. You might have thought this, but this doesn't work. So rather, due to the fact that the merciful one did not write the verse that way, but instead wrote, fathers shall not be put to death for children, doesn't say for their children, rather for children, which indicates that people shall not be put to death based on the testimony of fathers who do not have common lineage with their children. Learn from this formulation that with regard to a slave who has no common lineage with those above him or those below him, he is the one who is disqualified from bearing witness. But with regard to a convert, since he has common lineage with those below him, he is fit to bear witness. And if you would say, let the merciful one write, nor shall children be put to death for their fathers, why do I need that which the merciful one wrote? Nor shall children be put to death for fathers, right? Without the word there in between, it doesn't say children relating to their fathers, but children relating to fathers generally. which indicates that people shall not be put to death based on the testimony of children who do not have common lineage with their fathers. And the Gemara answers, since the merciful one wrote, fathers shall not be put to death for children, he also wrote in the same manner, nor shall children be put to death for fathers. So that was a long way of proving that Canaanite slaves are not fit, are disqualified from being witnesses in capital cases, but converts are qualified to bear witness in capital cases. Now, new subject. The Mishna on page 87a taught, with regard to a deaf-mute, an imbecile, or a minor, an encounter with them is disadvantageous, since one who injures them is liable for causing the injury. But if they were the ones who did the injuring, the imbecile, the deaf-mute, or the minor, they are exempt. They don't become liable for their actions because the imbecile doesn't understand, the minor is not legally competent, and the deaf-mute, according to what they had back then, which was a lack of sign language, etc., they couldn't be sure that the deaf-mute understood what was happening. So the Gemara relates an incident. The mother of Rav Shmuel bar Abba from the city of Hargonia was married to Rabbi Abba. And she wrote, i.e. signed over her property to Rav Shmuel bar Abba, her son. So after she died, now we're on 88b, Rav Shmuel bar Abba went before Rabbi Yirmiyah bar Abba to claim his mother's property. And Rabbi Yirmiyah established him as the owner of the property in accordance with what was written in the document. So Rabbi Abba, the mother's husband, went and said a report of the matter before Rav Hoshaya. And Rav Hoshaya went and said a report of the matter before Rav Yehuda. And Rav Yehuda said to Rav Hoshaya, this is what Shmuel says. In a case of a woman who sold her usufruct property, so that's property that she brought into the marriage, and while she's married, her husband is entitled to the produce, right? Meaning, let's say she brought a field into the marriage. So while they remain married, the husband can plant the field, and he keeps the profit from the crops that come from that field. That's the produce of the field. But if they get divorced, she takes her field and goes on her way. What she brought into the marriage, she leaves with it, in addition to whatever he owes her under the terms of the ketubah, the marriage contract. So that's her usufruct property. This is what Shmuel says. In the case of a woman who sold her usufruct property, which belongs to her, but whose profits her husband garners, if she sold it in her husband's lifetime, and then she died, the husband repossesses the property from the purchasers. The granting of her property by means of the document is analogous to a sale. And Rabbi Abba can repossess the property from Rav Shmuel bar Abba, right? So this is a sale that was not authorized. Even though it is her field, since her husband has the right to the produce while they're married, she can't sell it. And then when she dies, the husband, it has a right to repossess it under certain conditions. So the sages said that halakha, that law, before Rabbi Yirmiyah bar Abba, who had ruled that the property belongs to Rav Shmuel bar Abba. And he said to them, I know the Mishnah that supports my opinion. As we learned in the Mishnah, in this tractate on in Bava Basra, page 136a, in the case of one who writes a document transferring ownership of his property to his son, right? That's why we're talking now about property law. Like, remember, we were talking about if you injure somebody, whether you owe them damages or not. Then we were talking about Canaanite slaves. Then we were talking about Canaanite slaves and their lineage. And now we're talking about who can inherit what from whom. And that's how we got here. So based on that kind of digression trail. So in this case of one who writes a document transferring ownership of his property to his son, stating that the transfer should take effect immediately, but the son will have use of it only after the father's death, the son cannot sell the property due to the fact that it is still in his father's possession. The father said, I'm going to give you this property, so it's now officially yours, but I'm going to keep using it until I die, and then you'll have both legal ownership and physical ownership of the property. Until then, I'm going to keep using it. And the father, even though he retained the right to use the property, he cannot sell the property due to the fact that it is written as belonging to the son. So if the father sold the property, then it is sold to the extent that the purchaser may use it until the father dies. Then it will revert to the son. If the son sold the property during his father's lifetime, the purchaser does not have the right to use the property until the father dies, right? And so that's how we're going to make a distinction between the actual owner of the property and the one who has the right to use the property. And then what happens if a sale is made by one or the other while the rights are still split. So Rabbi Yirmiyah bar Abba infers, in any event, if the son sold the property during his father's lifetime, when the father dies, the purchaser has rights to the property. And this would be so even though it is a case where the son died in the father's lifetime, where the property never came into the son's possession. So Rabbi Yirmiyah bar Abba's analysis is in accordance with the opinion of Rabbi Shimon ben Lakish, who says there is no difference if the son died in the father's lifetime, where the property never came into the son's possession, and there is no difference if the father died in the son's lifetime, where the property came into the son's possession. In any event, the purchaser acquired the property. So it's a valid sale, even though the one making the sale only possessed a partial right in the property. Now, the Gemara records a dispute between the Amoraim, the sages of the Gemara, with regard to this point. As was stated, in a case where the son sold the property in the father's lifetime, and the son died in the father's lifetime, Rabbi Yochanan says the purchaser did not acquire the property, and Reish Lakish says the purchaser did acquire. So the Gemara explains the opinion of Rabbi Yochanan, right? So remember that the father gave the son the land. Now the son is the legal owner of the land, but the father retained the use of the land for the rest of his life until the father dies. And now we're saying that the son sold the property while the father was still alive. Presumably what he sold is the idea that the buyer will come into the position of the son. The buyer will now own the property, but he can't get the full use of it until the seller's father dies, because the seller's father has that right to keep using the property as long as he's alive. So was the son able to sell that legal right without the right to possess? Rabbi Yochanan said no. Reish Lakish says yes, right? So let's see, where was I? Okay, so the Gemara, Reish Lakish says the purchaser did acquire. So now, Rabbi Yochanan says the purchaser did not acquire the property because he could have said to you, when the Mishna teaches, Rabbi Yochanan could have said to you, when the Mishna teaches that if the son sold the property during his father's lifetime, the purchaser does not acquire any rights to use the property until the father dies, and one could infer that when the father dies, the purchaser has rights to the property, then the Mishnah is discussing a case where the son did not die during the father's lifetime, so that the property came into the son's possession upon the father's death before the purchaser acquired it. But if the son died in the father's lifetime, so that the property never came into the son's possession, then even when the father dies, the purchaser does not have rights to the property. Presumably Rabbi Yochanan is saying you can't sell something unless you both have legal title to it and the possession of it. And if you don't have both of those things, the sale is not a sale. So the Gemara comments, apparently Rabbi Yochanan holds that the ownership of the rights to use an item and to its produce is considered to be like ownership of the item itself. So even though the property itself did not belong to the father, it is as though the father owned the property because all of the produce belonged to him in practice. Therefore, when the son sold the property, he sold property that did not belong to him, and that's why it's not a valid sale. Now, Reish Lakish, Rabbi Shimon ben Lakish, who says that the purchaser did acquire, explains like this. Reish Lakish says that the purchaser acquired the property based on this claim. When the Mishnah teaches that if a son sold the property during his father's lifetime, the purchaser does not have any right to use the property until the father dies, so one could infer that in any event, when the father dies, the purchaser has rights to the property. And the Mishnah therefore means that there is no difference if the son did not die in the father's lifetime, where the property came into the son's possession. And there's no difference if the son did die in the father's lifetime, where the property did not come into the son's possession. In either case, the purchaser acquired the property because the son had the underlying right of ownership. That's what he sold. That's what the purchaser got. And he's just going to have to wait until the father dies before he can take possession of the property. So it is a valid sale. So apparently Shimon Reish Lakish holds that ownership of the rights to use an item and to its produce is not considered to be like ownership of the item itself, and therefore when the son sold the property, he sold property that belonged to him, the underlying right, even though you can't take possession until the father dies. So now the Gemara returns to the discussion of the opinion of Rabbi Yirmiyah bar Abba. And now, for us, whether if one discusses the opinion of Rabbi Yirmiyah bar Abba and whether one discusses the opinion of Rav Yehuda, they both hold in accordance with the opinion of Reish Lakish, that ownership of the rights to use an item and to its produce is not considered to be like ownership of the item itself, like in the case of a husband and wife. So he has the right to use the property, the right to the produce of the field that she brought into the marriage. And she owns the underlying property that, if the husband dies, she'll regain that field. Or if they divorce, she'll regain that field and go with it and have full use of it, right? So can she sell it while they're still married and the husband has the right to it? What she might be selling, akin to what the father and son were talking in the case before of Reish Lakish and Rabbi Yochanan, what she might be selling is the right to receive the field when the marriage ends, right? So that the buyer is saying is okay with the idea that I'm buying something, I can't make use of it. Your husband has the right to use it while you're married, but if you die, if he dies, if the husband dies, or if they divorce, the field reverts to the woman, and at that point, that purchaser would receive it, and that's what he's purchasing. And Rabbi Yirmiyah bar Abba says, if it enters your mind that ownership of the rights to use an item and to its produce is considered to be like ownership of the item itself, then when the father dies and the son had died in the father's lifetime, why does the purchaser have rights to the property? When the son sold it, didn't he sell property that did not belong to him, like a wife selling property that belongs to her technically, but that the husband has the rights to it, and she's able to sell it if the son is able to sell something that his father has the right to use. So rather, isn't it correct to conclude from the Mishnah, says Rabbi Yirmiyah bar Abba, that ownership of the rights to use an item and to its produce is not considered to be like ownership of the item itself? Therefore, Rav Shmuel bar Abba should receive the property that was transferred to him by his mother, as the fact that the husband owned the rights to the produce does not limit her ability to transfer her property to her son. And the sages brought back Rabbi Yirmiyah bar Abba's reply before Rav Yehuda. And Rav Yehuda said to them, this is what Shmuel said. This law that a husband can repossess the property that his wife sold before she died is not similar to the law of our Mishnah concerning a father who transfers his property to his son while retaining the right to garner the profits. So in both cases, there's one party that has a right to use the land and another party that has the underlying ownership of the land. Yes, the two cases have that in common, but no, they're not the same, because in one case, a father, gave his son the land and retained the right to use it during his life. And in the other, we have a wife who brought a field into the marriage, and her husband has the right to use that field while they're married, and if they divorce, she takes the field back. But the difference is they're married. Right? So the laws of marriage are going to be different than the laws of what a father can give a child. So let's see how. Wait a minute. Said Rav Yehuda. Yeah, they're not similar. That's what he said. They're not similar to our Mishnah. And the Gemara asks, what is the reasoning for distinguishing between the two cases? And Rav Yosef said, granted, if the Mishnah had taught the opposite and stated that in the case of one who writes a document transferring ownership of his property to his father after his death, with the son retaining the right to garner the profits until then, and the father sold the property during his son's lifetime, the purchaser has the rights to the property after the son dies, then it is possible to resolve from the Mishnah that ownership of the rights to use an item and to its produce is not considered to be like ownership of the item itself. But now that the Mishnah teaches specifically one who writes a document transferring ownership of his property to his son, the ability of the son to sell the property is due to the fact that it's not just two parties where one is saying, here, I'm selling you this land, or I'm giving you this land, and then I'm going to keep the use of it as long as I'm alive, and then you'll get the full possession of it as well as the legal ownership, because these two parties aren't just independent parties, they're a father and son. And what makes it different is that when the father dies, not only will the possession of the land come fully to the son because the father's right to use it ends when the father dies, but also the son is the inheritor of the father. So the son would have inherited the father's estate anyway. And that's an additional legal element in this analysis, right? So one who writes a document transferring ownership of his property to his son, the ability of the son to sell the property is, even while the father is alive, is due to the fact that the son is fit to inherit from him and already has a right to the property, and not just due to the existence of the document of transfer from the father to the son in which he retained the right to use the field while he's alive. So in the case of Rav Shmuel bar Abba as well, the woman's property is inherited by her husband, not her son. So she cannot transfer it to Rav Shmuel bar Abba. Husbands inherit their wives in a way that here is made akin to how sons inherit from their fathers. So Abaye said to Rav Yosef, is this to say that a son inherits from a father, but a father does not inherit from a son? There is no difference between their rights to inherit from one another, right? If a son dies while still, single and doesn't have his own children, then who inherits him? If his father is alive, his father inherits when his son dies. So there is no difference between their rights to inherit from one another. So rather, even if the Mishnah taught a halacha, a law, concerning a son transferring his property to his father, the son's reason for doing so could have been that he comes to hide his property from his own son and wants his father to inherit from him instead. Here too, when a father transfers his property to his son, he comes to hide his property from the son's brothers, as the father has other sons but does not want them to inherit from him. Therefore, the Mishnah's choice of case cannot serve as the basis for inference. So Abaye continues, rather, what was Shmuel's reasoning for saying that the right of a husband to the property that his wife sold before she died is not similar to our Mishnah that states that a father does not have rights to property sold by his son? The difference is due to the rabbinic ordinance of Usha. The ordinance of Usha. That was an ordinance instituted with regard to the husband's rights to his wife's property. Now, when we talk about the ordinances of Usha, we're talking about a city in the north of the land of Israel, sort of near the Mediterranean and at about the level, north-south-wise of the Kinneret, the Sea of Galilee. And the reason it's important is because after the destruction of the Second Temple, the Sanhedrin, moved from Jerusalem to Yavne. That's where the sages sort of reestablished the seat of Torah learning in the wake of the destruction of the Second Temple that the Romans destroyed in approximately the year 70 of the Common Era. Some say the year 69. And then the seat of the Sanhedrin actually moved a few more times. And so these ordinances of Usha, these were passed about 70 years after the destruction of the temple and a few years after the Bar Kokhba rebellion, which was a rebellion that was terrifically unsuccessful against the Roman Empire and resulted in a real genocide of the Jewish people in Israel. And at any rate, the government, the Sanhedrin moved up. And now in the wake of that, massive tragedy and loss of life, they're sort of trying to get their bearings again, and then they were, continued their exploration of the law that they'd been doing for, hundreds of years to get it all squared away. And one of these ordinances has to do with husbands and wives and understanding who inherits who. But that was passed in Usha when the Sanhedrin had been relocated to Usha after the Bar Kokhba rebellion. Okay, so what is this ordinance of Usha? It was an ordinance instituted with regard to a husband's rights to his wife's property. As Rabbi Yosef Bar Chanina says, in the town of Usha, the sages instituted that in the case of a woman who sold her usufruct property in her husband's lifetime and then died, the husband repossesses it from the purchasers. And this ordinance was instituted only for the benefit of a husband, but not for the benefit of a father or son. It's beyond the scope of today's class to talk about, what motivated this policy consideration. Why was that law necessary? I mean, was it just an interpretation and that they finally understood what the Torah was saying? Or was it some kind of historical circumstances in the wake of that massive destruction? At any rate, they are saying that if a wife sold her usufruct property while her husband was alive and then she died, the husband can repossess it from the purchasers. So Rav Idi Bar Avin said, we too learn of the ordinance of Usha in the Baraisa. If witnesses said, we testify about so-and-so that he divorced his wife and gave her the full value of the obligations recorded in her ketubah, her marriage contract, and she is under him and serves him, i.e. she was still fully married to him, and then these witnesses were found to be conspiring witnesses who were attempting to deny this woman the ability to ever collect payment of her ketubah, then the court does not say that the witnesses shall pay the entire value of her ketubah. Rather, the court says that they shall pay the financial advantage of her ketubah. And the Gemara explains, what is the financial advantage of her ketubah? The court evaluates how much a person would want to give to purchase the rights of this woman's ketubah, taking into account the law that if she becomes widowed or divorced, the purchaser will receive its full value, but if she dies before her husband, then her husband will inherit her property and the purchaser will receive nothing. Right? So she receives money from the husband or his estate if she survives him as a widow, or if they divorce. But if she dies first, then there is no payment. So somebody might purchase the financial advantage of a ketubah, right? It would be a discounted price because maybe she needed money during her lifetime, and so she found someone that said, "Okay, fine. Your ketubah is worth $1,000." So I may or may not collect it in case you die before your husband. So, I'll give you $400 for it. And she needed the $400, so she took the deal. That kind of a thing. So I'm almost done. So if you have questions or comments, please get them in. So Rav Idi Bar Avin continues, and if it enters your mind that there is no ordinance of Usha, why would her husband inherit from her? Let the woman sell her marriage contract entirely. So Abaye said this is not a proof for the existence of the ordinance of Usha, because even if there is no ordinance, and the sages said that the woman retains the right to sell with regard to the usufruct property, would they also say that the woman retains the right to sell with regard to guaranteed property, which is listed among the possessions that she brought into the marriage, but is entirely under her husband's authority? In any event, there is property that she does not have the right to sell, and that the husband would inherit if she dies, regardless of whether or not there is an ordinance of Usha, so the marriage contract could not be sold for its full value. So Abaye, and that ends that part of the discussion. So Abaye said, with regard to financial advantage, since discussion of this matter came to us, let us say something about it. The money received for selling the financial advantage is given only to the wife, for if it enters your mind to say that it is given to the husband, then let the conspiring witnesses who have been rendered liable to pay a penalty to the wife say to her, what loss have we caused you by testifying that you had received payment of your ketubah already? Even if you were to sell it for the financial advantage, your husband would have taken it from you. Since this is not the case, it must be that she has something that she can sell and keep herself. And Rav Shalman said in response, she still would incur a loss because there is a gain to the household. Even if the husband were to be the one to receive the payment from the sale, the financial situation of the household would be improved, leading to a concrete benefit for the wife as well. and this offsets the wife's potential loss. And Rava said the law is that the money received for selling the financial advantage of the ketubah is given only to the wife, and the husband does not even garner the profits from that money or from the property the wife would purchase with that money. And what is the reason? The sages instituted that the profits of her property are for the husband, but the sages did not institute that the profits of the profits are for him. So you can see, certainly, that it was a very patriarchal system and that women were at a disadvantage vis-a-vis men. But you can also see that given how, completely patriarchal the ancient world was, where really, generally speaking, women had no rights whatsoever, the Torah provided rights for the women, and the sages expanded those rights a little bit through their interpretation of these verses. Okay, that's what I've got for us today. Let's take a few comments or questions as this reloads. Bava, Kamma, 88. Load. Sorry for the delay. Jonathan, if you are a convert, does that also mean you have the legal status of an orphan? That's a very interesting question. I would say no, right? No. Because when we're talking about the legal status of an orphan, we're talking about they have certain protections that, usually when we're talking about the legal status of an orphan, we're talking about a minor who is protected by the court and will have a guardian or a custodian that will make sure that in business dealings, that are made with the father's estate, that the orphans are protected so that when they inherit, and they're adults and they can take care of their own affairs, they will receive an estate that was not, ripped off by unscrupulous people who would take advantage of orphans. In terms of other aspects of the law, where being an orphan comes up, I'm not sure offhand. But the bottom line is that a convert is a Jew in every way, except they don't legally have parents, and that's why their Hebrew name is, Ben Abraham or Ben Sarah. And I can't think of other cases that, maybe it'll come to me, I'm just not thinking of it now. And Joseph said, did these rabbinic councils leave minutes of these meetings and write down the pronouncements, or was it all oral? Certainly teachings, it's a great question. I don't know that there are, like written decisions, like, every decision that the Supreme Court of the United States ever issued was in writing, can be researched, full of footnotes, etc. The Sanhedrin, it would be what kinds of rulings. In criminal cases, they would just say, guilty or innocent. I would imagine that there was some record keeping of what all the cases were, but I'm not aware of any, like just the written minutes or like, the what do you call it? What's that word? The written out proceedings of a court, the transcript of the proceedings of the court. But there's also the Sanhedrin, acting as the sages of the generation, making legal rulings on halachas that are going to affect the Jewish people wherever they might be living. And those are preserved, right, initially as oral teachings and then later set down in the Mishna and in the Gemara. Nina's giving me a note that the Cairo Geniza had some documents like that, perhaps the transcripts of earlier courts. And Joseph also says at the beginning of today's daf, speaking about the father and son, is this referring to Ezekiel 18, the son shall not be punished for the sin of the father? No, right? That's what I'm saying. It sounded like that. But the way the sages understood that verse was not, because it said, fathers shall not be, put to death for children, nor children shall be put to death for fathers. And it doesn't say for their fathers or for their children. And that's why the sages interpreted that what it really meant, right, is that Fathers are not going to be put to death by the testimony of their own children, nor by the testimony of people who are not legally connected to either their parents or their children, which they read as disqualifying Canaanite slaves from testifying in capital cases. That's what I've got for us today, and with God's help, we'll be together again tomorrow for page 89 here in Tractate Bava Kamma, and we've got 2 short pages coming up, and so that's going to be an opportunity for us to double up and get caught up. We're still running 2 pages behind the normal Daf Yomi schedule, so God willing, tomorrow we'll make up one of those. Have a great night.